access to information laws, if they're strong laws, require all information to be public unless it needs to be withheld to protect some larger interest, like, for example, national security or privacy or relations with other states. But within those laws, if they're strong laws, they will also have a public interest override. Even if releasing this information may, for example, harm national security, we're still going to release the information if overall, on balance, the public interest is served by that. My organization has a methodology for assessing the strength of the legal framework for access to information, and we have assessed all 140 national laws. So 140 countries have national laws. A lot of countries, like my country, Canada, we have one national law and 13 subnational laws. The United States has 50 states, each of them has their own law. We haven't assessed all of those laws, but the 140, we've assessed them all. And I mean, there's some very, very strong performers. For example, Sri Lanka, Afghanistan is actually the top law. I know it's a bit odd, but they passed a really strong law before the Taliban took over, and the Taliban have left that law in place even though they don't apply it. This methodology just looks at the law. The Philippines, with its executive order, is in the bottom 10, for example, so lots to be done there. In my opinion, it's a breach of the Constitution not to have a law. The Constitution guarantees it, but it can't operationalize it because there's a lot of details and that's not in the Constitution. You need a law to give effect. When you have a constitutional right that's guaranteed, it's incumbent on the country to give effect to that right. That's why what the Constitution means. So, to me, it's absolutely the key need.